All right, Dave, we're ready to get started.
Okay, great. Thanks, Anna. I want to say hello to everybody and Happy New Year. My name's Dave Zapponi. I'm the Executive Director of ECHO, otherwise known as the Educational Council for Homeowners. Thank you for participating in today's ECHO live stream event on alternative and internal dispute resolutions for HOAs, featuring Spencer Edgett and Tim Flanagan. ECHO is a statewide nonprofit association created to support HOA board members and engaged homeowners. Our mission is to foster a better quality of life in community associations through education, advocacy, and connection. Before we move on with the program, please note this live stream webinar is scheduled for an hour and a half, including 20 to 30 minutes of Q&A after the presentation. Attendees will be muted during the presentation. Please use the chat feature for technical issues and use the Q&A feature for content-related questions. We will be vetting and answering questions as they come in. We have over 300 registered attendees. We will try to answer all questions, but due to the time constraints, we may not be able to. Please always be courteous and respectful of meeting participants. We reserve the right to mute or remove participants at any time and for any reason. This program is copyrighted by ECHO and will be recorded. We do not give permission to others to record the meeting without prior authorization. A copy of the recorded program, along with the presentation slides, will be emailed to each registered participant within 7 to 10 days. Finally, none of what is being said at the meeting shall be construed as specific legal advice from either the speaker or ECHO. If you wish specific advice, please, we encourage you to ask your attorney. I want to thank our premier sponsor, Tinley Law Group, and our Q&A sponsor, Pacific Western Bank, for generously supporting our program today. We will now hear a brief message from our premier sponsor, Tinley Law Group.
Hello, and thank you for allowing me to introduce Tinley Law Group. We're an HOA law firm that's been representing homeowners associations for over 30 years. We love working with our client family over 1,000 communities in a wide variety of practice areas, including assessment collection. In fact, in 2013, we developed Altera Assessment Recovery, which is quickly becoming an industry leader in the area. Our Find HOA Law web library is also another example of our modern approach to adding value to our clients. We hope to have the opportunity to work with you and to develop a relationship with you and your community.
Thank you. At this time, we will begin our program.
Hello.
Alternative and internal dispute resolutions for HOAs. I would like to introduce our speaker for today. Spencer Edgett is a partner with Chapman Intrieri LLP, and since 2004 has primarily focused his practice on representing community associations both as general counsel and in successfully litigating and resolving numerous complex multi-million-dollar construction defect claims. Mr. Edgett also regularly advises and assists community association managers and board members on all aspects of management operations, including fiduciary responsibilities, drafting and revising governing documents, vendor contract negotiations, collection matters, and enforcement issues. Tim Flanagan is a senior partner and shareholder with Flanagan Law, APC. Flanagan Law represents homeowner associations in general counsel, enforcement litigation, and assessment collection recovery. Tim has been practicing law for 14 years with the past 10 years dedicated solely to the representation of homeowner associations. Tim is very active in industry and recently had a case published in the Court of Appeals, making it easier for homeowner associations to pass CC&R amendments. Tim lives in San Diego with his wife and 2 boys. Thank you. Spencer and Tim, please begin.
Thanks, Dave. I think we're going to start off with a question just to begin the program. Annie, you want to hit us with that feedback question?
I sure will.
Thank you.
All right. So let us know who you are. Let us know if you're a board member, a homeowner, or a professional service provider. We'd like to get a good feel of of our audience today. So I'll give you guys just a few minutes, or a few seconds. And then I'll go ahead and share those results. Okay, so I'm going to end the polling. Let's see, and I will share the results with you guys. So you guys should see on your screen, we have 68% of you are HOA board members, and then 21% are homeowners, and 11% are professional service providers. So I apologize if I cut it off before you could vote, but yeah, so it looks like we have a good amount of board members and homeowners, and it looks like 15 professional service providers.
Thank you, Dave. Thank you, Hannah, and thank you for that great poll. That's, I guess, one of the upsides of doing this virtually is we have the technology to do things like that. But we do look forward to seeing folks in person when we can just have people raise hands. Wouldn't that be nice? So let me just talk about, first what we hope you take away from this. We're going to be talking about dispute resolution in the form of internal dispute resolution, often referred to as IDR, and alternative dispute resolution, often referred to as ADR. And we hope the takeaway from today should be a better understanding about what these procedures are, how they differ, and when they are required. And really to appreciate that these are not simply procedural roadblocks or something that needs to be done so that you can check the box before filing a lawsuit. But these are really tools that you can use to effectively and efficiently resolve disputes and hopefully avoid costly litigation. And that is really the intent of these procedures, and that's why they are codified in the Davis Stirling Act, and also many of you have them in your governing documents as well. I think there's a misconception that when parties are entrenched in their positions, when a dispute arises, that the only way to resolve the dispute is to go to court. And everybody wants to get their lawyer and go to court and then have a judge or a jury decide in their favor. But that's not reality. The vast majority of cases, regardless of if it's before or after a lawsuit is filed, resolved through some form of dispute resolution. Typically, that's mediation. So even if you do go ahead and file a lawsuit and you litigate a case and spend all kinds of money on attorney's fees, at some point you're going to sit down at a mediation and probably get your case resolved. So you can either do that at an early point in the process before you incur significant legal costs, or after both parties have incurred significant legal costs and have litigation fatigue. Sometimes that's necessary, unfortunately, for both sides to have that litigation fatigue and, as we say, bleed a little bit. And often paying large legal bills can soften folks' positions. But if you have an opportunity to avoid that, it's almost always in everyone's best interest. And we hope that we're able to provide you with some guidance on how you can use IDR and ADR in order to accomplish that objective. So what are we talking about when we're talking about disputes that are subject to IDR and ADR? And right here on this slide, we've got a couple of different types of disputes that you might encounter that would involve IDR or ADR. The first one is assessment disputes. This is assessment collections, and under Davis Stirling, if you are going to record a lien or pursue a foreclosure, you are required to participate in IDR, certainly before you record a lien, and IDR or ADR before you commence foreclosure proceedings.
Hey, Spencer, real quick, I just want to jump in on that. I think what you meant to say, you're supposed to at least advise the owner of their rights to participate in IDR or ADR.
Thank you. That is correct. So that is true that you don't always participate in that process, but you do have to offer it to the member. That's accurate. And hopefully, if you offer it, the member is going to accept it. And we'll get into a little bit more details later on about when you're statutorily required to participate in the process and how that works. But this just gives sort of a general idea. But thanks, Tim, for that clarification. Architectural violations, improvements that are made without approval or maybe in conflict with an approved application could be subject to IDR or ADR. Parking violations, if people are using unauthorized spaces or parking without permits, if they're required. Nuisance or neighbor disputes, and we have here fair housing issues listed as well. I think some of the most complicated disputes that we run across are neighbor to neighbor issues. And oftentimes boards want to, shy away from that and say, look, that's a neighbor to neighbor issue. We don't need to get involved. That's not really the case. If you do have a neighbor to neighbor dispute that involves a violation of the governing documents, certainly you have an obligation to enforce the governing documents. And you may come across fair housing issues. If you have a situation where the dispute between neighbors maybe involves one of the neighbors yelling obscenities at the other neighbor, and maybe they're based on race, religion, sexual orientation, those types of things. If you don't do something, you can be hit with a complaint from fair housing. And so, you do want to get involved. Well, you don't want to get involved, but you necessarily have to get involved sometimes in those disputes to avoid larger problems. And you can use
Hey, Spencer, I just want to touch on that really quick because I've been participating in the CAI National Law Seminar this past week. And we know that there's a change in administration with the federal government. It's now Biden-Harris. And there's been a HUD requirement since 2016 that boards have to get involved with discrimination type issues like you were talking about, Spencer. And so, it's been there for 4 years, but now with Kamala Harris in office, she's been very active when she was Attorney General with the state of California as far as, looking after these types of issues. So I think that was pretty much the attorneys on the panel's opinion that we're going to be seeing a lot more of these HUD type lawsuits filed against associations that don't at least investigate and act on these fair housing HUD issues. Not to get too far out of the foot in the field, but you were talking about that. I think it's just important for boards to know that.
Yeah, that's great. Thank you. And current, obviously. So that's very helpful. Appreciate that. So beyond that, we have here listed any and all HOA disputes. The reality is, I think it's my opinion, and Tim, I think you probably share this, that there's really such a benefit to resolving disputes early if you can, that any and all dispute, regardless of whether you're mandated by statute or required by your governing documents, you really should consider and try to engage in some form of IDR or ADR to resolve the dispute to avoid litigation. And so, again, I think there are obviously requirements to participate in IDR and ADR, but always consider it in any dispute. Last point here, reasonable accommodation requests. And the reason we put this in here is because there is, if anyone is aware, an interactive process that is required under state and federal fair housing laws to address a reasonable accommodation request by an individual with a disability. And the interactive process should not be confused with any form of dispute resolution. It is a completely separate process, and it's kind of beyond the scope of this presentation, but we just don't want you to be confused that the IDR ADR is a substitute for that process, although it can overlap. You can have, IDR involved in a situation, where you have to engage in the interactive process. So that's all that we have for bullet points on this slide. There were a couple of things, Tim, I just wanted to add too before we move on. With new SB 323 election laws enacted last year, there is a requirement in there for IDR if you're going to try and disqualify a candidate from the board of directors. So I think people need to understand that that is a statutory mandate, and it can affect your election timelines. If you do, there are new strict timelines that you have to follow. And if you have to do IDR to resolve an issue of disqualification of a board member, then that can impact that. So you should be aware of that. Additionally, we don't have on here construction defect claims or SB 800 claims for newer communities. Oftentimes in your governing documents, you're going to have alternative dispute resolution that deals with those types of claims. And there are statutory frameworks under SB 800 where you do have a very detailed pre-litigation process. But those are claims that involve the owners or members and the developer, but not member HOA disputes, which is primarily what we're going to be talking about today. So sorry, go ahead, Handy. I think you have a poll that you wanted to put up.
Yes, so I'm going to go ahead and launch this poll for you guys. Again, we'd love to get your feedback. All right, so this is a pretty simple one, just a yes or no question. Do you know what an internal dispute resolution is? I know that Spencer just covered it, but we'd like to get a feel of the audience and where they're at with internal dispute resolution. Give you 5, 4, 3, 2, 1, and polling. Okay, so I'll share the results with you guys. So we have 63% say yes, 37% say no. So
okay, that's not too surprising, you know, Hannah. If you can move on to the next slide.
Sure thing.
You know, in my experience, I think that, and I think Spencer's as well, that IDR has just been an underutilized process in community associations. So, you know, when I first got involved with community association law 12 years ago, I noticed that there was, at that time, a little bit more of a divide between homeowner association boards and some of the owners. It seemed to be a lot more contentious as far as, you know, board members thinking that, you know, maybe having personal fights with owners and then not involving them into, you know, some of the ongoing communications with the board, with the community. And I think that's just changed a lot more recently. And I think more and more boards are understanding that if there's a dispute between a member of the community and the association, that using the IDR, internal dispute resolution process, effectively can really resolve those disputes. And the key is you want to have as much harmony as you can in your community because you're living with those people. So these people who you have a dispute with now, they're your neighbors. And so it's key to try to do all you can to resolve those disputes for that moral reason, but also, like Spencer was touching base on, you do not want to go to lawsuits. You do not want to go to litigation. You know, Spencer and I have both gone to trial many times on different enforcement matters. And when you do that, even though the HOA can be successful and get their attorney's fees back, the process itself is very, very painful. Not only are you incurring fees for your attorney, but in the meantime, you're battling with this homeowner. There's people taking the homeowner side versus the board side. You're feeling stressed out and you're a volunteer. So anything we can do to resolve that before we get to litigation is key. So what is internal dispute resolution? Again, it's a dispute between the homeowners association and a member of the community, not a tenant. So there's not a dispute between the tenant and the board. It's not a dispute between the management company and the member. It's not a dispute between the board and a vendor. It's between a homeowner, member of this community, and the board of directors and the association. What is it supposed to be? It's supposed to be very informal. So what I mean by informal, or is that you don't have to have a very strict process where people have to be in front of a mediator or an arbitrator or a judge. It's supposed to just be where one board member sits down and talks to the member face to face, and try to hash out the differences in the dispute. You know, just sitting down in a conference room kind of deal. So it's supposed to be very informal, and it's supposed to make everyone comfortable so that you can just talk out this dispute before it gets worse. It's supposed to be between a board liaison and a member. And what does that mean? Well, what I've seen a lot, and this is how we're going to talk about this a little bit more, but how you can really derail an IDR is having not one board member or one board liaison, but have the entire board there in front of the member as if it's a disciplinary hearing. If you do something like that, you know, just imagine you're a homeowner and you're before 5 board members and you're trying to plead your case. It feels almost like you're in front of a court. And so what the state legislature wants to do is avoid that feeling where the member is intimidated by the whole board and just having a one-on-one kind of conversation. And we'll talk about that a little, like I said, the strategy of that moving forward. But I think that having the one board member there and the one homeowner member is a greater ability to resolve the dispute. Attorney involvement, I see Hannah's hinting that I should move on and be a little faster, so I'll move faster. But attorney involvement, that's brand new in the code. That only was entered in the code about 3 or 4 years ago. Before that, attorneys were not supposed to be involved. And since the code has changed, I've actually participated in a number of IDRs with my communities that I represent. And at first I was hesitant because I don't want the association to have to spend attorney's fees on this type of issue. However, I do have noticed that when you have a Tim or a Spencer attending the IDR, that the chances of resolution is a lot higher, but you just have to be wary about how you approach it with the owner, and make sure that the owner knows ahead of time that the attorney is going to be participating, and then they may bring their own attorney as well. Usually what I do is, I let the owner know that my participation will, although I represent the homeowners association, will be there to try and attempt to facilitate a resolution.
Hey, Tim, here's just a question, and this comes
Sure.
up a lot. How does a board or a property manager know when they should bring in an attorney? Should in every situation, should they call their general counsel and ask, hey, do we need you involved? Or, is there any type of a triggering event where they say, wait a minute, we need a lawyer here? What are your thoughts on that?
I don't know if there's a triggering event. I mean, definitely if they have an attorney, that's the triggering event.
Yeah.
So if the homeowner's attorney is saying, I want to participate in IDR, you got to send it to your general counsel or get an attorney involved, because you don't want the board unrepresented with another attorney there. And besides that, I would just leave it. It's really going to be on a case by case and fact specific issue, because it really depends on what the issues are and how contentious the dispute is. If it's very contentious and there's a lot of hostility back and forth, get your attorney involved. Then you have a little bit of the nice thing about having your attorney there is that you have that break. So you don't have to respond when you're mad. You can talk to your attorney, and your attorney, who's not part of the dispute, can communicate those issues to the homeowner member, and maybe do so in a less emotional manner that may help bring on a resolution to the dispute. And do you want to touch on real quick in person versus virtual before we move on to the next slide?
Yeah, we could talk about that. I mean, obviously now in the situation with, COVID, everything is really virtual. And so any type of dispute resolution that we're doing now, at least that I've been doing, has all been on a Zoom platform. I think even once we are able to get together, that we are going to be using the Zoom platform on occasion. It has shown to be pretty effective in terms of its ease of use, and scheduling is obviously a lot easier, and certainly if you have attorneys involved, it cuts down on travel time and costs. But at the same token, there really is no substitute for being in person and getting together and trying to sort out differences. I think that if all you can do is Zoom or virtual, it's better than, nothing, or doing it over the phone. It's nice to actually look into somebody's eyes and see who's across from you. But always I think in person is better. Yeah.
And like we were talking about too, if the code specifically says that the board needs to meet, or a board member needs to meet with the homeowner. But I think that meeting requirement can definitely be meeting via Zoom or virtually, and especially with COVID. So next slide, please, Hannah. Okay, so when is IDR required? So under the code, an association may not file a civil action regarding a dispute in which a member has requested dispute resolution until the association has complied by engaging in good faith in the internal dispute resolution procedures after a member invokes those procedures. So again, this is Sacramento, a couple of attorneys up in Sacramento writing a very convoluted law that basically means that if a homeowner is in a dispute with the association, and the homeowner says, I want to participate in IDR, in internal dispute resolution, the homeowner association has to comply and has to participate in the internal dispute resolution process. If the association does not, then they could be out attorney's fees, and a motion to strike or demur could be filed against the complaint if they went that far, for failure to participate in the dispute resolution process. And one of the key things that I want to highlight on this as well is the engaging in good faith, because that's where my experience has been, where IDR fails most often, is where the board will think of IDR as a hassle. And I think some of those thoughts have come in over time by maybe bad experiences with IDR, or maybe a manager saying that IDR is a waste of time. But I would always enter into any of these processes. You're taking your time with an open mind and with the eye on the prize that we're going to resolve this dispute. Maybe you can't do it. Sometimes you got to go to litigation, but do everything you can to protect the corporation and see if you can resolve the dispute before you have to go to litigation. What do you think, Spencer?
Yeah, I agree. And you know, another comment on this is if you know, not always does a member even understand that they have a right to request IDR. So oftentimes, if the way this statute's written, you could get away with, you know, well, they didn't ask for it, so we don't have to do it. But you know, and my feeling is it's worthwhile to alert the member that they have this right and try to engage them in the process, and not just, again, like I said from the outset, this isn't just a check the box thing. This is a tool that you should be focused on utilizing to try and resolve disputes. So although the statute, technically you could get away with just not worrying about it if a homeowner doesn't ask for it, I think you ought to offer it at the outset of a dispute and say, look, this is a right that you have. You know, annually with the annual policy statement, you know, your IDR procedure it goes out to the membership, but you know, not everybody reads that or understands it. And you know, I think that it's a benefit to tell the member that you have a dispute with that, you know, this is your right, and do you want to engage in this? Let them know and see what they say.
Yeah, I agree, Spencer. Hey, Hannah, would you move on to the next slide, please? Thank you. What is the procedure for IDR? So first off, there's two different procedures. You have a default procedure in the Davis Stirling Act or the Civil Code. It's also called the Davis Stirling Act, is what we mostly refer to it as. And that default procedure, frankly, is pretty good. And it explains exactly what the board must follow if they don't already have a procedure in your governing documents. If you want to have your own procedure, in your governing documents, is probably going to be like an IDR, ADR policy. It probably is not going to be located in your CC&Rs. If it is in your CC&Rs, then you must definitely follow it. And it's going to be very hard to change. If it's an IDR policy that's in your rules, you can change that as time goes on. So for example, it's 2021. We've been doing Zoom meetings for a year now. And the HOA puts in their IDR policy that IDRs can be held via Zoom to accommodate both the members and the board of directors. You could do something like that and put that in your rules and regulations. The only thing I'd caution boards on doing is once you put anything into the rules, you're bound by and you must follow. So if you had something that's very odd and different than the civil code, then you got to make sure that you're always participating in that and following the policy. One key that is we didn't put in the slide here, but to start off the whole process, you know, the dispute must be put down in writing to the board of directors. So sometimes I've heard, you know, board members complain about something that's going on in the community, or complain about a neighbor. They can talk, say they want to do this and that. Until there's something in writing, there's really nothing to do as far as an IDR. And so sometimes if, like, let's say, for example, a homeowner writes a complaint to the manager and says they want to, you know, talk to the board about that, you know, perhaps a writing back to that owner and asking if they want to participate in the IDR process, and then have them specify exactly what that dispute is. And I think that's very key, because once you have that, well, number one, it forces the homeowner to think about exactly what the issue is, okay? Because emotions can get involved here, because we're talking about our properties and our homes. So it actually requires them to sit down and think about exactly what it is. And then it also lets the board know exactly what the issue is as well. So that when you come together at the IDR, you're working on a shared and common goal, and you're not working on two different objectives and two different issues.
Tim, let me interject one thing. In terms of the process for initiating IDR, do you think that, or do you find that typically IDR happens before there's a violation in a hearing, or is it after there's a violation in a hearing?
It really happens anytime, but usually it's after a disciplinary hearing.
Right.
So, you know, there's a violation that's occurred. The homeowner doesn't think that they violated anything, or they think that the board is after them for some reason, or the manager's after them for some reason, and they get upset, and then they want to participate in an IDR. Very rarely, but it does happen, or a board will initiate an IDR with a homeowner, and and that can also be affected. And I've actually counseled boards on using that process. It doesn't mean the homeowner has to participate. That's one thing to bear in mind. But it will let the owner know that the board is taking this issue seriously, and that they are hearing the owner and understand that there is an issue. So that does have some importance. So the statutory default procedure, I talked about that. It's outlined in the Civil Code. One of the things that I think is important, and somebody wrote it on one of the chat items, is there's a timeline involved here. So the code doesn't say like you must participate in IDR within 30 days. It just says require parties to meet promptly. What does promptly mean? There's no case law that has taken a look at this word and this term and said, okay, that means blank. But here's how I've always counseled boards on this, is that if you receive a request for IDR, first thing you have to do is acknowledge the request and let them know that you'll be back in touch with them as soon as possible. I would say 48 hours, because there's somebody so hot about some issue that they want to participate in IDR. And if they got to wait a week or 2 weeks to hear back from the board, that's just going to make things much, much worse. I'd really respond within 24 hours. Say, hey, we got your request. We'll be in more touch with more details shortly, but we just want to let you know we got your request. And then I would set something up within a week. Doesn't mean you have to participate in the IDR within a week, but I would get on the same page with the owner and say, okay, are you available on this date at this time to meet with this board member? I would really say would it be less than 30 days, even though there's no code section on this. And really, I would, within a couple of weeks is what I'm looking at as far as that term promptly.
And I would just add, Tim, this is something you and I had talked about the other day, which is, another fine piece of legislating up from Sacramento, is that there is a default procedure under 5915, but the code also states that if you have your own adopted procedure, it mandates certain things that must be in that procedure. And one of the things, interestingly enough, is the maximum time to respond to a request for IDR. So if you're under the default procedure, it just says promptly. But if you adopt your own process, you're mandated to include a maximum time to respond. So that if you do have your own procedure, you should look at that, and maybe 30 days or 15 days, whatever. Tim, you seem to think it should be a lot shorter, and I think it depends on the circumstances. Obviously, sometimes it's difficult for boards to move that quickly because they have to get together and have an executive session to discuss and notice and all that. But it is just sort of an interesting note that if you have your own procedure, the legislature says you have to have a maximum time to respond, but the default procedure doesn't say anything about it.
Yeah, and I kind of want to, I already see it's 1:35 and we have to wrap up, but I also want to do say that executive session is only 48 hours notice. And frankly, there should already be some kind of process baked in for your community. And when I say 24 hours response, I'm just saying there's a response back to the owner, letting them know that you've received their request.
Absolutely.
Not saying that you got to participate that quickly,
Sure.
But there's really, frankly, no reason why it should take more than 30 days. And really more than a couple of weeks to get that involved. Sometimes it happens, that's for sure. Okay, can charge a fee to participate. And if the member can appeal to the entire board. If there was no resolution to the dispute, or as we read yesterday in the code, if it's not put in writing either, the board can appeal to the entire board. Or the member can appeal to the entire board. And then
again, that's the non-default procedure. Another conflict in the non-default procedure. There's a right to appeal that doesn't appear in the default procedure.
And then most importantly, if you reach an agreement, it must be in writing. And I can't stress this enough. Not only does the code require it, but that's the whole goal, is to have something that's written down and then you can reach back to and say, this is what we talked about. This is what we discussed, and here's what we agreed to. If you don't have it in writing, then there's going to be, question about what was actually resolved, and it could lead to further disputes. So make sure it's in writing. And now let's talk about effective strategies, because I think that's key for this entire program in my mind. And Hannah, if you want to move on to the next slide, is really just dealing with some effective IDR strategies here. So first off, establish goals and objectives. And this is where we're talking about having it put down in writing, the actual IDR request. I think that's key, because then we understand what the goal is of the person, or what the dispute is, and then you can talk to the other board members and have goals and objectives in mind with that IDR. But the goal and objective obviously would be to resolve this dispute, and whether or not you guys can do it, that's something you're going to have to discuss ahead of time. So the board member who's participating in the IDR understands what his or her limitations are when they are talking about that dispute. So for example, a homeowner is upset about a fine that they got. And the board knows that the homeowner is deserved of discipline, and but they want to participate fairly and in good faith in the IDR. They may say, well, listen, we still want the owner to know that what they did was not right, and we want to discipline them. So maybe we will, reduce fines, we'll eliminate fines, pending no further violations. But that person who's participating in the IDR must know of that goal and objective of the board before they go into the IDR. Act in good faith. We already talked about this, but I can't even tell you how often I've seen these disputes go away when there's one homeowner who feels that no one ever listens to them. They aren't taken seriously by the management company or by the board. And they sit down and they talk to one board member who is actively listening, and they get to discuss this and hash out the issue. And then all of a sudden, the anger disappears because somebody actually paid attention and listened to their opposing views. It doesn't mean you have to agree with their point of view, but sometimes they just like to be heard. So definitely act in good faith. And frankly, you want the goal of trying to resolve the dispute if possible. One board member participation, we talked about that as well. The code requires a single board member. Having the entire board there is not going to resolve the dispute, and in fact is just going to be like another disciplinary hearing almost. And I think it's really key too that the board member that is chosen to participate in the IDR is a board member who the owner does not have some sort of problem with. So when I'm working with an IDR with my communities, I will ask the manager, or I'll communicate directly with the owner and say, okay, the IDR is scheduled for Thursday, and Mr. Smith is going to participate. And sometimes the person will say, anyone but Mr. Smith. I'm fine with anyone else. Okay, that's fine. We'll ask someone else to participate. I just think it makes sense, because you're never going to resolve the issue. You're only going to harden the hearts of both sides if you have, even a perceived difference between the owner and the member, or the owner and the board member. So I really think that you should pick and select your board member participant wisely. Use a facilitator, and this is where we get into whether or not to use an attorney. When I do participate, I do act as a facilitator, although I represent the homeowners association. And what I really would like to do when you sit down in a IDR, although it's informal, I have these kind of just a little process in place where I will say, okay, everybody, we're here to talk about this dispute, and I'll actually read the written dispute. And then say, first, we're going to have the board member tell their side of the story. We're not going to have arguments or shaking of the heads or sighing or hissing from the other side. And then the board member will tell their point of view for the association. And same thing with the owner. You're not going to be shaking your head, sighing, rolling your eyes, interrupting. And then after that, we can have this discussion. If you divide it up like that, I find that both sides get a chance to talk. And then the facilitator needs to say, okay, well, what can we do to resolve this dispute? Here's what I've heard. What can we do to get this resolved? And then you kind of go down your checklist. and you may or may not be able to resolve any one of those issues, but by using that facilitator, you help keep the discussions and negotiations going. Can you use a board or another board member to do that? Potentially, but I wouldn't be wise to do that. Can you use a manager to do that? Absolutely, but this is all based on what the manager, their experience is, and whether or not the homeowner has some kind of ill feelings towards the manager as well. Act promptly, we talked about that. The key is just keep it moving and you'll get it resolved a lot easier than if you wait. If you wait, you're going to get people upset. And then, exercise discretion. I think that's key because, you definitely don't want to resolve a dispute that, sometimes you're not going to be able to resolve every dispute, right? But what you want to do is make a decision that's in the best interest of the community, because that's what you're there for. You're there to represent the homeowners association, not your personal interests, and also not the homeowner's sole interest as well. So you got to do what's best for the association. Anything that I covered, or did I miss anything, Spencer? Did you want to touch on?
Yeah, let me just touch on one thing. I just saw a question. It is a good one. And we're about to talk about alternative dispute resolution and mediation, which always involves a third-party neutral. But under the code for IDR, it says that the association shall use to the maximum extent possible the assistance of a third-party neutral and low-cost mediation programs that are available. So, I always view IDR as not involving a third-party neutral because there's a cost associated with that. It's more of a meet and confer with the board. But you can use a third-party neutral, if you want. And what is your experience, Tim? And what is type of recommendations do you have whether or not you should ever use maybe a low-cost mediation service as part of your IDR procedures?
Well, I don't know if I'd put it in my procedures if I was going to adopt a policy. But if a homeowner said, "Hey, listen, there's a local," and there's so many neutrals out there, and there's so many different type of mediation companies and facilitators out there that'll do no cost or very, very, very low cost mediations. I think it's fine to participate in that. You'll see, frankly, a lot of churches will have something like this. So maybe if there's a church, that you guys both feel comfortable with having a pastor act as a facilitator, go ahead and use that person. The key is, though, if there's any kind of charge, so let's say it's a $50 charge to use a local person in the community who handles these matters, the HOA's got to eat that if they're going to use that facilitator. It might be money well spent, but you can't charge that to the owner for IDR. ADR is a different story, but for IDR now. How can you, real quick, I saw in the chat, how can you find a low cost facilitator? I would just Google. I know they're out there, especially in bigger cities. You're definitely going to find them in, San Diego, LA, Orange County, the Bay Area for sure. Sacramento. Smaller communities might not find them as much, but they're definitely out there. I would just Google.
Well, in the court, you might talk. The courts sometimes have panels that are available depending on the county you're in. You can call your local bar association too. So.
Yeah.
Okay. I think Hannah, we have a poll coming up next.
Yes, we do. Okay, let me go ahead and launch that. Okay, so the question is, have you participated in mediation? This is a yes or no question.
We need some Jeopardy music.
I know, that would be great. Feel free to do some a cappella. Okay, 5, 4, 3, 2, 1. Okay. All right, so 43% said yes, and 57% said no.
Excellent, but 50-50. That's actually more than I anticipated, so that's great. Really, really good. So for those folks that haven't, hopefully we can teach you a little bit of something about what mediation looks like. All right, so next slide here, Hannah. All right, so first, what is alternative dispute resolution? So the Davis Stirling Act defines alternative dispute resolution for HOA and member disputes, and it says it means mediation, arbitration, conciliation, or other non-judicial procedure that involves a neutral party in the decision-making process. The form of alternative dispute resolution chosen pursuant to this article may be binding or non-binding with the voluntary consent of the parties. All right. So the first thing to note is that in the name alternative dispute resolution, what is it an alternative to? Well, it's an alternative to go into court. That's really what we're talking about. It's any method of resolving a dispute short of filing a lawsuit in a court of law where it's going to be decided by a judge or a jury. So the first significant difference between alternative dispute resolution and IDR is that ADR always involves a neutral third party, okay? And it says it right in the statute there. And we talked about you can use it in IDR. In that circumstance, the homeowner cannot be charged. With ADR, the parties share the costs. So who are these third-party neutrals that are involved in ADR? Typically, they are experienced attorneys, or they could be retired judges. They may be independent, where they have their own dispute resolution firm or company, or they may be part of a larger ADR service. Some of the larger ones that we're familiar with are JAMS and AAA. Those are both national service providers of dispute resolution services, and they're readily available in, across the state. They do charge a fee. They can be quite expensive, and typically they charge, maybe lawyer rates are oftentimes higher. I'd say they range between $300 to $1,000 an hour. On the higher end, those mediators that charge $1,000 an hour, the reason they can do that is because they're in high demand, and they just keep ratcheting up their rates until they can fill their calendars. And so those types of mediators are typically only going to be selected for large multi-million-dollar construction defect cases, because it's just, pretty expensive to pay somebody $1,000 an hour. So I'd say generally the range is somewhere in the 300 to 500 range, depending on the level of experience. In selecting a mediator, obviously I would, we'll talk about mediation in a minute, but if it's any neutral that you're going to use in this process, I think you really want them to be experienced in HOA law. They really should understand what a community association is, how it operates, what CC&Rs are, what a board of directors is, and what their roles are. I think that's critically important. So the most common form of ADR that you're going to deal with is mediation, and that's probably 99% of the time. We're talking about mediation. Arbitration is also available. It is alternative to court, but it's usually only required if it's in your CC&Rs. And typically arbitration is going to be mandated for disputes with your developer, again, for construction defect type claims. It's generally not mandated between the association and the owner for any type of disputes, but it can be agreed upon. This also talks about conciliation. I don't know. I think generally people figure that's synonymous with mediation. I don't know, there's a different conciliation process. And then there's other non-judicial processes that can be agreed upon, but, they're pretty rare outside of, mediation, arbitration. So that's really what we're going to focus on. So mediation, what is mediation? Mediation is a voluntary process. The mediator is usually selected and agreed upon by the parties. And as I said, you should select one that is knowledgeable in HOA law. It's very, very difficult in these types of situations if you have to get a mediator up to speed on the workings of an association and what the governing documents are. That's going to be an uphill battle. So you really want somebody that's familiar with homeowners associations and community associations and has, resolved many of those cases. The mediator's role is not to take sides, but to resolve the case. They are working for a resolution. They're not working for one side or the other. As we talked about earlier, due to coronavirus, we're doing mediations virtually over Zoom. It's still very effective, easier to schedule. I think it's going to become more common even when we're able to get together, and I think it's perfectly fine. Again, I always think in person is better, more effective, but so far I've found that virtual Zoom mediations are pretty effective. We've resolved plenty of cases that way. However, typically when you have a mediation, you are going to go to a specific location. Could be a neutral site at the attorney's office or at the one of the attorney's offices, or you could have it at the community. If you have a clubhouse and space available with multiple rooms, you could have the mediation on site. Generally, before the mediation, you're going to provide a mediation brief. The mediation brief will have the factual and legal underpinnings that support your claim. Everything that's said in the mediation brief is privileged, and this is a very important component of mediation. Not only the brief is privileged, but everything that's discussed in mediation is privileged. And what that means is if you don't resolve the dispute and you end up going to trial, nobody can later use it against you and say, well, your mediation brief said X, or you said this in the mediation. It can't be used. It is as if it never happened. Okay, so that's very important. And what that allows for is a candid and frank discussion to occur at mediation. The mediation, almost always involves attorneys. I would say, I would not recommend you do it without an attorney. Again, there's obviously added costs to have an attorney there, plus you're paying for the mediator, but it's always going to be far less expensive than going to having litigation commenced. And again, like I said earlier, most cases resolve at mediation anyway. So you can either do it early or you can do it later after you've spent a lot in litigating. The format of mediation, it depends really on the parties' decisions and the mediator. Sometimes there's a joint session. I'm not always a big fan of joint sessions. What that means is you have all the parties in one room together with the mediator, and everybody gets to tell their side at the outset. And sometimes that just sets a bad tone, especially if it's really contentious. So normally my preference is to not have a joint session and just start in separate rooms. And then the mediator kind of goes back and forth and will try to facilitate a resolution. And usually the mediator will go into your room if you're sitting there and tell you all the things that are wrong with your case and why you should settle. And they're going to be doing the same thing on the other side. It's really counterproductive for them to pump you up and say, geez, sit tight, you got a really great case. They won't get it resolved. Again, their job is to try to resolve the case. And at the end of the day, mediation, it's not going to resolve unless the parties agree. The mediator is not going to make a decision. The mediator can make a recommendation, sometimes what's called a mediator's proposal, and either side can accept or reject. But at the end of the day, it is a voluntary process, and the only way it resolves at mediation is if both parties agree, and the resolution is going to be memorialized in a written settlement agreement, and that settlement agreement will be enforceable. You can take it to court and have a judge enforce it if one of the parties doesn't perform what they agreed upon. I think with mediation, mediators often say that if both sides are a little bit unhappy, it's a successful result. I think that's probably true, in most cases. Typically, one side doesn't come out feeling victorious and the other side a loser. A good result is when everybody's maybe just a little bit unhappy, but again, it's always better than going to trial. And again, if you do go to trial, the power was taken away from you to fashion some type of agreement that you could obtain at mediation. There's, trial's binary. There's a winner and a loser, and your fate is in the hands of the judge or the jury. At mediation, you control it. So it's a very effective process. I don't know, Tim, anything on mediation?
Yeah, I mean, you said a lot, Spencer, and I think you're very comprehensive. One thing I'd like to touch on, though, is participation for the board. If you're participating in mediation, I strongly recommend that the entire board participate in the process, if possible, especially if it's something that is really a hot issue. It tells everybody involved, even if you don't actually participate and meet the other side because you're in separate rooms like Spencer was talking about, the mediator can say, hey, the whole board's in there, in that other room, or they're participating virtually. That just lets everybody know how important it is to the community. Can you have one homeowner or one board member be there? Yeah, but beforehand, you'd have to make sure that you've given that board member some kind of level of authority to settle. And you're gonna have to do that in an official board meeting. And then the problem with that is, if that individual board member is told, okay, I can pay, $5,000, and then there's a $6,000 offer that sounds really good, well, that person doesn't have the authority to bind the association to that extra $1,000 that could potentially resolve the lawsuit. So it's probably better if the entire board participates. in the mediation for the association.
Yeah, I agree with that. And it's a lot easier when you're doing it over Zoom because people can be in different locations and we've got people working from home. So it's that, most of my mediations more recently have involved the entire board. But in the past, when we get together in person, sometimes that's more difficult with people's schedules. And what we do in that situation, if people can't attend, we at least have people on telephone standby so that the board member that is there with authority, if you get into that situation where you're really close, but you just need to go maybe $500 or $1,000 over your authority, the board is available on standby. You can get them on the phone and take a vote and go above the authority. So yeah, really important point, Tim. All right, so let's, I know we're getting there. Got to get into some Q&A. So I'll try to get through the arbitration section a little more quickly. So arbitration is, oftentimes people confuse mediation with arbitration, and they are completely different. Arbitration is really essentially a trial. And it's a trial, but instead of having a judge or a jury in a courtroom, you have an arbitrator that is deciding the case in a private setting. And so you'll use the same types of service providers. JAMS and AAA will provide an arbitrator. And but you're doing discovery, although it's limited discovery in arbitration. You can take depositions, and you do need an attorney, and you are going to have a hearing. And the hearing will not be in a courthouse. Typically, it will be in an office somewhere. But you will put on your case. You will put on witnesses. You will introduce evidence, and at the end of the day, you will have a decision rendered by the arbitrator that is an enforceable award that can be reduced to a judgment and enforced by a judge in a court. So arbitration is, although it's an alternative to trial, it is also, very expensive. And, you lose control like you have in mediation because somebody is deciding your fate, the arbitrator. The arbitrator is typically an experienced attorney or retired judge. Again, it's essentially, like having a trial. And the difference with arbitration is you do have to pay the arbitrator, and arbitrators are, can be expensive. So there's a lot of cost there. Some people think that because there's limited discovery, you spend less in attorney's fees. Maybe that's true, maybe it's not. But at the end of the day, it is expensive. You can have non-binding arbitration. I don't know why you ever would. There can be circumstances where maybe it makes sense, or just if you want to have a non-binding arbitration on one issue that might be a sticking point, that if you had a non-binding arbitration and a decision on that, it might help you get the case resolved. But because it's so expensive, if you're going to do arbitration and the parties agree, then you might as well make it binding, and that will be the end of it. The nice thing about arbitration, though, is it can be more expedient. Courts get really backlogged. It's hard to get a trial date. With arbitration, as long as the arbitrator is available and the parties agree, you can set arbitration, whenever you want. It's a lot more flexible. I don't think there's much more to talk about arbitration. So let's talk about the next slide. What is a procedure? Sorry, I think you had to go back one there, Hannah. Okay, so the procedure for ADR. So how does this work? Well, actually, go back one more slide, Hannah. When is ADR required? Okay, so an association or member may not file an enforcement action in Superior Court unless the parties have endeavored to submit their dispute to ADR. So that doesn't mean you actually have to have it. You just have to endeavor or try, which means make an offer, see if the other side will agree to mediation. Maybe they won't. If you've made the offer and they refuse, then fine, you can go ahead and file your action in Superior Court. You are required to file a certificate that states that you did endeavor to participate in mediation. And if you don't file that certificate and you didn't endeavor to go to some form of ADR, your case can get dismissed under demurrer or motion to strike. The other issue, if you do not try to participate in dispute resolution before you file an enforcement action, you can have lose your right to attorney's fees. Your attorney's fees can be reduced if the judge finds that your refusal to participate or failure to endeavor to participate in ADR was in bad faith. So this applies to certain circumstances. Any enforcement action, if you're enforcing the governing documents, or an enforcement action coupled with monetary damages that doesn't exceed the amount of the small claims court's jurisdiction, which is about $5,000. If the money of it at issue is greater, You don't need to participate in ADR, but I always would recommend you try. Again, it's always better to try to resolve this before you get into court. Go ahead to the next slide there, Hannah. So any party may initiate the process. Similar to initiating IDR, you have a brief description of dispute, your request for ADR. So you'd say, we'd like to participate in mediation. There are specific timelines. If you have 30 days to respond to a request for ADR, if you don't respond within 30 days, it's deemed rejected. If the party is a member, then you're also required to provide them with a copy of the Davis Stirling Act that deals with ADR. Next slide, please, Hannah. So again, timeline, 30 days to accept. Once the ADR is accepted, you have 90 days to complete the process, or that timeline could be extended by written stipulation of the party. So just be careful if you're getting close to the 90 days, that you get it in writing that both parties have agreed that the process would be extended. And then ultimately, either you reach a settlement or not, and you're going to go to trial. So that's sort of the process. The court costs of ADR are borne by the party, so ultimately you're going to share the costs. During the time period that you're participating in ADR, if there is a statute of limitations issue, meaning for those of you who don't know what a statute of limitations is, you have a certain time period to bring certain claims. Typically an enforcement action is 5 years. But if you're running up against a statute where you're going to be time barred, during the period of time that you're in the ADR process, the statute is told and protected, so you don't lose your rights. And again, we already talked about this, but if you don't participate in ADR or attempt it in good faith, you can forfeit your right to recover attorney's fees, even if you prevail, or the attorney's fees can be reduced. Okay, next slide there, Hannah. All right, so effective strategies. So one of the things, I think one of the most important things to set up for a successful mediation is to have a good mediation brief. Your mediation brief should really educate the mediator on the facts and law that favor your position, and also educate the other side. Let the other side know, tell them what your case is and why you're going to win. And I always want to exchange briefs for that reason. I think if you have a strong case, there's no reason not to exchange briefs. But sometimes folks don't want to exchange briefs because they feel that maybe they're compromising their position if the case doesn't settle, so they want to submit a confidential brief. So if parties want to submit a confidential brief, that's fine, but I would always try to advocate to exchange briefs. I think it can be a very effective tool. In terms of your role in the brief preparing process as a board member or a homeowner, I think you should really be engaged in that process with your attorney. Have your attorney provide you with the draft of the brief and weigh in. The attorney doesn't have all of the knowledge, obviously, that board members and homeowners have. So you might be able to inject some facts that may be helpful that the attorney wasn't aware of. So really be engaged in that process and have a really good mediation brief. Involving counsel in the ADR process, I think, is paramount. I think it's very important. Certainly being in mediation can be a daunting experience. And if you haven't had experience in mediation and you don't know how it works, and even if you have been to mediation once or twice, it really takes, going to a lot of mediations to understand how the process plays out and how different mediators operate. Oftentimes if you didn't have when I'm in mediation with some of my clients, the mediator will come in and say, you got a good case, but we're never going to get you anywhere near $100,000. That's not going to happen. And your board might have said, well, we're never going to settle this if we don't get $100,000. And they look to me and say, well, we're never going to get $100,000. Let's leave. So I say, well, hold on a minute. That's, the mediator's just trying to test the waters. They're trying to soften everybody up. I know they told you you'll never get $100,000, but let's let the process play out. So your attorney can be there to, kind of let you understand the strategies that the mediator might be employing, and also, help you weigh sort of cost benefits of settlement. If you get to a point where, maybe it's not exactly what you wanted, but, you need your lawyer to guide you and tell you, look, this might be better than the risks going forward. Tender to your insurance carrier. Obviously, if the claim is something that's going to be covered by your directors and officers or a CGL policy, tender it early, and you should talk to your broker about that, talk to your attorney about that. unless the amount at issue isn't much and you have a high deductible. If you have like a $10,000 deductible and there's 5,000 at issue, then maybe it's not worth taking the hit on your premium. But the reason why tendering it is important early is because that is the triggering date for when the carrier, if they decide coverage is available, will be on the hook for attorney's fees. So you can get your attorney's fees back from the carrier post tender, but until you put your carrier on notice, you're going to be on the hook for those attorney's fees.
One other thing to note on that, Spencer, and I think we got to kind of get to our Q&A time, but another thing, if you do not notify the carrier, a carrier may later on interject that they weren't notified properly pursuant to the policy. So they could reject or deny a claim after a mediation and claim that they weren't properly put on notice of it. So I at least notify the carrier. You may not want to fully on tender, but definitely notify the carrier as soon as possible.
Good point. Absolutely correct. You do have an obligation under your policy typically to notify them of any claim that might be triggered, that might trigger coverage. So that's a good point. And Tim talked about this a little bit for the IDR, but have realistic expectations and expect compromise. You're never going to get everything you want out of mediation. It's a compromise, and so the objective is to resolve it and avoid litigation if you can. It doesn't mean you roll over and just accept whatever is available on the table at mediation, but be prepared to compromise your position. Listen to the other side, listen to the mediator, listen to your lawyers, and understand that it is about compromise. And then finally, just precedent setting and board discretion. The reason we put that in is sometimes boards feel that it is their duty to enforce the letter of the governing documents, that if there's a violation, that it is just unacceptable and you must enforce all violations and take it to the mat, because if you don't, you might set a precedent for future disputes. That's not the case necessarily. You do have to think about precedent, but once you're involved in a dispute resolution setting and faced with potential litigation, the board has discretion to do what's in the best interest of the community. And going to trial on some issue might not be in the best interest of the community. So you might decide, look, in this circumstance, we're going to allow whatever, it is. Maybe somebody built a deck that was 1 foot, larger than they were supposed to. And maybe you let it go in that circumstance. So you're not always setting precedent. The board does have discretion. And, the ultimate goal is to resolve the dispute if you can. But also, you do have an obligation to do what's in the best interest of the community. Okay, that's all. Anything else, Tim, on ADR strategies before we get into some of the Q&A?
No, I think you really covered it. I mean, the key is make sure the board's prepared, have a mediation brief, use an attorney, and then have a mediator that's vetted and that you know about and that is good with HOA disputes. Because sometimes if you don't have that, then the mediation could drag. I think you covered all the good points there, Spencer.
Okay. All right, well, let's take a look at, Hannah, you want to bring up some of the questions, or you want us to go through?
Yeah, we have just the last final poll that'll lead us into that. Let me launch that real quick. Okay, so after what you learned today, do you feel that the IDR and ADR process could help resolve any existing or future disputes you may have? Yes, no, or I still have questions. And hopefully you put those questions in the Q&A, we can get to them. All right, I'll give you guys just a few more seconds. I know we have a lot of questions to answer today. 5, 4, 3, 2, 1. All right, yes, so 82% of you, which is 113 people, said yes.
That's surprising, wow.
There were still people voting when I cut it off, so it looks like so yeah.
I'm glad to hear that though, because that's good. That means that you guys, by doing that, you're going to resolve a lot of disputes, and you're taking actually the proper fiduciary role for your community. So, but it looks like we have a number of questions here. Hannah, are you going to walk Spencer and I through these?
Yes. And I just want to thank you guys also for your time, and let's jump right into the Q&A. And again, this Q&A session is sponsored by Pacific Western Bank and Tinley Law Group. So thank you both. So yeah, I'm going to read some questions. Tim, Spencer, if you guys see some good questions in there, feel free to read them to the audience and answer them. But yeah, we'll work together on it.
Okay.
Right here, I'll just start with the first one. Can you request an IDR via email, or does it need to be a physical letter sent, registered, or signature release in order to ensure it has been received?
So I'll take that, Spencer. If you don't, I'll take that first
Sure.
one.
Yeah, go ahead.
Yeah, so there is nothing in the code. It just says that's to be in writing. Frankly, I think email's fine. But if you are requesting an IDR, so if you're an owner wanting to request IDR, I would probably say, let's consider this. I would like to consider this email my request in writing. If you're a board and you get an email, same kind of thing. I'd write back and say, this is confirming this is your request in writing for IDR. And then then that way you've covered that base.
Okay, and so if they send that request, who should that be sent to? All the board members, the manager, if there is one? What do you suggest there?
Well, if there's a manager, that should be the agent for the association, and the manager would be sending out that request to all the board members. So send it through the manager. You know, the problem is, like, a lot of board members, you know, if they get a direct message, I would always counsel them not to necessarily talk to somebody individually, because they could be taking on fiduciary risks by saying something they shouldn't be, and without the entire board agreeing to that issue. So it's best to send it to the manager, and then the manager will pass it on to the board. If there is no manager, send it out to the entire board.
Okay. All right. Let's see. And there was one about, does this apply to IDRs referring to foreclosures or regarding foreclosures?
Yes. You are required to participate in either IDR or ADR before you move forward with foreclosure. And I think that's one of the circumstances where actually, you know, you do have to advise the member of their right to IDR or ADR. But yes, this is the IDR that you would be involved with, not only for foreclosure, but to record a lien. Before you can record a lien, you have to at least offer IDR.
Yeah, so generally what you have in that is it's just like a generic letter that says, hey, this is to advise you, if you dispute your debt, you have the ability to participate in IDR or ADR. 99% of the time, that doesn't really happen. But yeah, it's very similar. It just, you know, it almost never happens.
Okay, here's one here from Randall. Smaller associations don't have ready access to an attorney. So what is your advice in this situation when attorneys are not, they put in quotes, at the ready?
Okay, Randall. So, okay, well, I don't know if you're on your board or not. I represent homeowners associations, not homeowners. So I would recommend, if you're on the board and there's an ADR or an IDR brought against the community, to look up somebody, you know, maybe who's on the ECHO website or locally who's an HOA attorney, and then reach out to them and get them involved. So you don't necessarily need to have a general counsel person involved, but I know a lot of general counsel attorneys like myself. I represent smaller communities, 28 homes, and I might not hear from them for a year, but they'll call me up every once in a while and we can talk about their certain issues. So that should be the case for your community as well. You should be able to find somebody out there, and you don't need to pay them a high retainer or anything like that on a yearly basis, just on an as-needed basis.
Well, and most of us will pick up the phone and talk to you at no charge. I mean, that's how, you know, we get business. So, you know, to say you don't need to have general counsel, you know, retained in order to reach out to an attorney and just explain your situation. And they might say, well, yeah, that's in a situation you can handle without an attorney. Or they might say, wow, you really ought to get an attorney involved. And to say that you're a smaller association, so maybe we can't really afford an attorney. Well, what you probably really can't afford is getting into litigation. So if you think that that might be a possibility, you've got a dispute that could lead to litigation, then reach out to an attorney. And if you have to come up with some money to pay them to resolve the dispute through IDR or ADR, you ought to do that and not wait. I think it's sometimes the self-managed communities that get into more trouble because they wait longer, because they feel that it's going to be too expensive to call a lawyer, or they don't have a lawyer, or they don't have a manager telling them you really ought to talk to a lawyer. that's when you kind of, get that phone call at the end that, hey, we're getting sued and, our answer is due in a week. And what do we do? It's like, well, hold on. How did this even get to a lawsuit? Why are you at this point? And now you've got to answer a lawsuit within a week. So just reach out, pick up the phone, make a phone call, do a Google search, find an HOA lawyer near you, and give them a call. They'll talk to you.
Okay, thanks, Spencer, and thanks, Tim. Here's one from Claudia. Can an IDR be used to dispute elections?
Yeah, so sure, of course. There's a new election law, and if there's an election challenge, it's spelled out in the civil code. But I see no reason why a homeowner who has an issue with the election process can't use the IDR process to talk about that with the board.
Yeah, and again, both of the IDR and ADR can be used to resolve any dispute. You can, it may not be mandated by code, it may not be mandated by your governing documents, but they are tools that you have available that you can always utilize in any situation.
So here's one from Janice. She said, you mentioned changing rules and regulations to allow the use of Zoom for IDR rather than requiring in-person meetings. Can a board adopt such changes without prior 30-day community review, or is prior community review required?
Okay, a few things on that. Sorry, Spencer. First off, I think what you mean as far as you can't change Zoom. When I'm talking about Zoom meetings and your rules, I was talking about IDR participation. Board meetings right now, because of COVID, I think everyone's going to look away that the code actually requires that there's going to be an in-person type of meeting. For IDR, though, I think you can have it, if you're going to put that in your rules, I would say something along the lines of the members will participate either in person or via Zoom as agreed upon by both parties. Because you don't want to have a situation where the board's like insisting they want to do Zoom and the other person wants to participate in person. I think both sides have to agree to that. Secondly, it's 28 days member review. 30 days that recently got changed to 28 days about 2 or 3 years ago. And yes, it would need to go out for a 28-day review and member feedback process in order for the board to adopt that rule.
And I agree with that, Tim. The only thing that I would add is that if you can enact an emergency rule, and we have done this with COVID, and emergency rules do not have to go out for a 28-day period. And I think the COVID pandemic is a perfect example of when you can implement, emergency rules without going out for the comment period. But those are only enforced for, I think it's 90 days. But you could use that circumstance. So if that's what you're talking about, you've got an immediate need to have a virtual meeting, but you can't due to the pandemic. I think you could adopt emergency rules to deal with that situation. Yeah,
just a couple quick thoughts on that though. First off, back in March of last year, agreed. That was
it was
a
little late.
January of 2021, probably not an emergency, but you're right. You can do emergency rules. I just don't think that changing the IDR policy would be an emergency. And then also don't forget, like you said, after 120 days, those expire. And so you got to make sure that you're going to adopt them as regular rules too.
Yeah, it depends on the circumstance. That's right.
Okay, this one from Shelley. We have a conflict resolution center that we've used for mediation. It's a nonprofit and they charge a low fee. They're good mediators. They're good mediators and also work for small claims court. They don't permit attorneys. Is that acceptable for ADR?
So, I mean, again, like I said earlier, I think if you're talking about mediation, you really ought to use an attorney. It can be very helpful. But if it's a minor issue, if it's a small dispute, then, maybe using that type of a service, might make sense without attorneys. So I think it's sort of a case-by-case basis.
We have so many questions. I'm like trying to search them for ones that would be good for the group.
Well, and again, I mean, everybody should know. I mean, like I said, you can always, if you do have, we're not going to get to all these questions, but you can call, attorneys that do work in this area, and ask them, questions, and oftentimes they'll give you, some time. So this isn't,
Let
your only
me-
opportunity.
Spencer, let me add in, there's Dave Zapponi.
Yeah.
We also have the Ask the Attorney sessions coming up, and that's 3-hour blocks of time with 15-minute blocks for various attorneys. And all the sessions are simply for our members to ask these type questions, and it's kind of on a first come first served basis. It's a really great opportunity. We have several of them coming up. I think in March is our first. And then we have our law seminar coming up, which we'll have attorneys there that can speak. And then our educational seminar, both of those are in March as well. So we have these forums regularly so you can actually participate in it. And most of them are free, and you don't need to be a member except for a couple of them. So
Excellent. That's great. That's great. Nice
Here's
resource.
one for you guys. If you had an ADR and an agreement was not in writing, can you pursue ADR even though an agreement was reached?
Yeah, I mean, you could pursue ADR. I mean, I think I'd go back and try to figure out, get that agreement in writing first, though.
Mm-hmm.
So, but yeah, I mean, if you went through the IDR process, agreement was reached, but it's not in writing, then technically you didn't really follow the code. You can go to the next step and go to the ADR process.
And if the entire board is at the mediation, does it trigger the Brown Act meeting notice requirements?
Well, first off, Brown Act would not apply. You're thinking of the Open Meeting Act, and no, it does not apply. It's not an open meeting. They're only there to discuss and really agree upon a mediation. They're not deciding and voting on an item of business that should be discussed in an open board session.
So there's questions.
This is all privileged. This is all privileged litigation kind of information.
Okay. So we have Charlotte here who asked, what's the difference between notifying the insurance company and tender to the insurance company?
I'll take that too. So, yeah. I mean, I think that one thing you can just say, listen, you reach out to your agent. Hey, we have this issue. This owner is asking us to go to IDR or ADR. We don't want to have the insurance company or insurance carrier, necessarily jump in and provide litigation defense at this point, but because we think we can resolve it, but we just notifying you so that you can keep an eye on it and the carrier can oversee it from afar.
Let's see. Thank you, Tim.
Welcome.
Well, some of these people are saying their questions were already answered, so try to make sure I don't ask those. Okay.
Yeah, I see one here. It says, an owner submitted an owner-to-owner dispute against the owner. The board has done nothing. Well, here's the thing with that. The weird thing about that is that the IDR process is only supposed to be between a board or an association and a member. So not between two members. Can you do it between two members? I think so. But the association, they're not going to owe that kind of duty to get involved in that. However, the only time is, like we did point out earlier, though, if it is involving discrimination, that could touch upon either a HUD regulation or a fair housing kind of regulation, then I do think that the board should get involved. And I have an example of that. So recently, I was talking to Spencer about that. Somebody in a community I represent had a flag up that was an old 1912 German flag. I'd never seen this. I had no idea what it was. The neighbor complained to the manager about it. He said that he thought it was discriminatory. I looked it up. The owner claimed it was because of its German heritage or something, but I looked it up and it was listed on the Anti-Defamation League as a symbol of anti-Semitic philosophies, and he had that flag pointed at his Jewish neighbor. So we had the owner take that flag down.
Okay, I've got one here for you guys that I got in an email. They said if our CC&Rs allow for attorney's fees, is this recovered from defendant only after the HOA wins at trial? In other words, if the dispute is settled via ADR, does each side pay their own attorney's fees?
So I could take that, Tim. I mean, that's a good question. If you do go to court and you are a prevailing party, you would be entitled to your attorney's fees, provided it's not knocked down because you didn't participate in ADR or not in good faith. But if you're in a mediation and you're resolving the dispute, typically you would factor that in to the settlement. And so you might say, well, you have this, improvement that was not authorized. So it's a deck that we want you to take down. And now we've incurred X amount in attorney's fees. So we want you to cover those attorney's fees. And that would be memorialized in a written agreement. So you can recover your attorney's fees in mediation, but it's by agreement. The other side would have to agree to pay some monetary amount for that.
And I see an interesting one about an IDR resolution. So Lynn had a IDR agreement with the board of directors with the association, but that they didn't follow through on their agreement. She wants to know if ADR is then warranted. Well, I think that if you have that written agreement, that's another key. You can enforce that agreement. So now you can go to court and say there's a breach of the contract or a breach of the agreement. So you could go to ADR, but you also have that written agreement to enforce as well.
Yeah, the IDR agreement is enforceable as long as it's not in conflict with the law or the governing document. So it's the same thing as a settlement agreement.
Exactly.
So I've got one here. If a member won't cooperate to go forward with mediation, should they wait for the member to file a lawsuit? The member previously filed and dismissed a suit and threatens again.
So if I had that factual scenario right, the member keeps on threatening lawsuits and the association asked to participate in ADR and the member refused.
I'll read it again. If the member won't cooperate to go forward with mediation, should we wait for the member to file a lawsuit? The member previously filed and dismissed a suit and threatens again.
Well, so here's how it would normally go. If the HOA is going to be enforcing an action and they're going to be filing the lawsuit, then the HOA is going to be the one who's going to be making the request for mediation. If the member is going to be filing a lawsuit against the association, then the member is going to be the person requesting the mediation before they go to that lawsuit. So, I mean, if the HOA doesn't have a dispute or doesn't plan on and taking any kind of enforcement against the owner, then there really is nothing for them to do. And if the member does sue them without filing an ADR request first, then if you're able to prevail at trial, you can get attorney's fees back from them, or even cause a motion for strike or demur to get the case dismissed from court.
Well, if I heard that question right, Hannah, they're refusing to participate in mediation, and I guess we don't have all the facts, but maybe they're refusing to participate in mediation, but for costs or whatever reasons. But you could still, request that they participate in IDR. In a meet and confer process if that hasn't happened yet. So
okay, so we've got time for just a couple more. Probably one more, I would say. Is this IDR process just civil code, or should it be spelled out in HOA documents like bylaws?
So it's in the civil code. There's a process in the civil code. It does not need to be spelled out in your bylaws or rules. And if you are going to spell it out, there are some requirements that you need to follow in the civil code. But frankly, I wouldn't even spend the time, because the civil code's process is pretty fair and reasonable.
Okay. Do you guys see any last? We got time for just one more. That one is a fairly quick one. Let's see.
Yeah, I got one here, Hannah. This says,
all right,
in our defective construction dispute, the attorney advised that we forego ADR and go directly to court. How do you feel about that? Well, I guess there's some facts there missing, but you are required to participate if it's an original developer dispute in a project that's under 10 years old. You are required to participate in the SB 800 process. And also, typically, the developer would have ADR provisions within the governing documents that are mandatory. The only time where you might forego that and go directly to court, I don't have enough information to know why the attorney is advising you of this, but there may be a statute of limitations issue that's coming up that requires you to file immediately, although the SB 800 process and claim notice tolls the statute. So it's a little bit unclear, but normally you're required to go through ADR before you can pursue a construction defect lawsuit.
all right. Thank you, Spencer. That's the last that we have for this Q&A session. And again, thank you, Tinley Law Group and Pacific Western Bank for sponsoring the Q&A.
Thank you very much.
And thank you, Tim and Spencer, so much. I just want to let everyone know about some upcoming events that we have. On February 13th and 27th, we mentioned this in the beginning, our Evaluating Hiring Community Management. And I'm going to announce this here, especially on this webinar. If you go ahead and register for this, use promo code 25OFF to get 25% off your registration. And we also have landscape lessons for 2021 coming on February 23rd, and that registration will be available by close of business tomorrow, presented by Kendall White with K&D Landscaping. So we look forward to these events and having you there. And I want to encourage everyone that's not a member of ECHO to become a member of ECHO. We have a lot of great benefits that we'd love to share with you. And if you're interested, you can contact Jay Price at echo-ca.org or call our office at the number 408-297-3246. I just want to thank everyone for joining us today, and a big thank you to our speakers and our sponsors. Thank you, Tinley Law Group and Pacific Western Bank, for making this program possible. And everyone have a wonderful day, and we'll see you next on February 13th for our part 1 of the management webinar series.
Thank you. Appreciate it.
Thanks, Hannah. Thanks, Spencer.
Thank you,
Thank you all.
everyone.
Bye.
Bye-bye.